No safeguards in law, and this is clearly the Islamabad High Court order establishes that no safeguard in law is a deterrent for the executive because they don't think that they have to follow any law. So private communication, tapping into private communication, and then we know that it is also used to blackmail to extract certain outcomes, especially from people in public office. In this surveillance debate, it's what is happening with encrypted platforms. SRO that has been issued essentially authorizing officers of the ISI to intercept communication and conduct surveillance is, in my view, an outcome of or a reaction to the Islamabad High Court order. And in that, the government was questioned, who has the legal authority, and clearly they had no answer. And this is also in keeping with the pattern that when they don't have legal authority for a practice that is anyway in vogue, what they end up doing is either issuing executive directives or passing a law. And so this is essentially in that vein. Now, Section 54 has already existed in the PTA Act, and the notification, the language is pretty much a copy-paste of that, right? So we also have to question how lawmaking is done and the kind of powers that are written in, and then the so-called legality of it all, right? And then in terms of the impact on the rights, I don't think that there is a balancing act happening at the moment between the rights of the right to privacy of individual users and counteracting with this vague national security phrase, because national security also has to be qualified, and any power has to be structured. It can't be arbitrary, overbroad, which we've seen happen. And so there has been a system in place without legal authorization per se, and now they've carved out so-called legal authorization through this SRO and are tracing it back to powers that exist within the PTA Act, but that also has to be read in tandem with the Fair Investigation for Fair Trial Act, which subjects any surveillance to warrants. And we know now, after the Islamabad High Court order, that in 11 years, no warrant has been sought. So all of this has to be, obviously, and then there's Article 14 and various other provisions and fundamental rights in the Constitution. So all of this has to be read together. However, the executive does not have that approach, and they just operate with the view that we have this power in law, or we can do this on the executive side, and it's supposedly legal, but I really don't think that's how it works. We have a history of unchecked abuse of executive power. And I mean, you can argue other organs of the state do the same, right? But in this case, definitely executive power, where laws and powers are instrumentalized against political opponents, against dissidents, against journalists, whether it's through surveillance, whether it's through, instrumentalizing, under the Prevention of Electronic Crimes Act to actually prosecute dissidents, or we see that they're enforced disappearances as a result of what people say. So obviously, the space to say and engage on things that, the red lines keep shifting. And so what are those red lines by the state as well? So private communication, tapping into private communication, and then we know that it is also used to blackmail to extract certain outcomes, especially from people in public office, and also, political parties, etc. We've seen all of this play out already. And so in this scenario, and this is something that historically has been established through various court cases and jurisprudence as well, we obviously know that this is what will play out. Secondly, what we now know of this so-called lawful intercept system is that it, the telcos and the others were fronted. So the private sector was told to procure and put this in place, absent, it seems, any lawful authorization. And 4 million at a time were being surveilled. So who are these 4 million who were being surveilled? To what end? And what kind of information has been extracted and put to use? So the whole purpose of a warrant, for example, under the Fair Trial Act, is that it has to be specific. You have to identify who, what, why. You have to qualify it before a judge of the High Court. And none of this has been done, right? And when you put in these systems, You think you're above all of that. So clearly, in this case, the executive has always thought it's above the law. And this is about successive governments. So the act has been in place since 2013. And any government who has been there has never one, authorized anyone formally, and then been conducting surveillance and not obtaining warrants. So this is another big issue with how these systems work. Who is it being applied to? And there are no answers and there's no transparency around this. In a recent op-ed that I wrote for Dawn, I have argued that what legal safeguards can possibly be an adequate check on these automated systems, right? And the lawful, so-called lawful intercept is one thing. Then we're hearing of a firewall. Then we're hearing of deep packet inspection technology and various other methods. So there is a lot of intrusive technology that has been procured, put to use. And how do you extend safeguard? So no safeguards in law. And this is clearly the Islamabad High Court order establishes that no safeguard in law is a deterrent for the executive because they don't think that they have to follow any law. The Fair Trial Act has existed since 2013. It requires a warrant. No warrant has been sought in 11 years. Where's the check and accountability for that? Under PICA, you require warrants for search and seizure, content disclosure, real-time monitoring. Where are these warrants? So once you put in place these systems, then it's circumventing even those legal safeguards, and the judiciary then has to subject them to the scrutiny. And we've not seen that happen either. There is this prevailing notion and it permeates society and state organs that something has to be done and national security has to be protected, and rights, if they are compromised, are just sort of part and parcel of this all. But you have to qualify for what purpose, for what reason. We are told that this happens elsewhere. No, that is not correct, because where it has happened, there has been surveillance reform, including the US, and there has been criticism. And even there are FISA courts. There is a lot of criticism about how FISA courts have rubber-stamped warrants as well, right? So we have to look at it holistically. Just saying that rights are a collateral in this larger scheme, and what is this larger scheme, and what is national security? It can't just be an unqualified phrase that is thrown around, which in this context it is. Digital rights advocates and civil society members have been saying for several years that there has to be transparency into it. In Pakistan, we've known for over a decade. Sometimes it's, for content filtering, we are told that certain equipment is required. Or there was a Citizen Lab report, was a NetSweeper, Finfisher, was detected in Pakistan, and then Sandvine equipment was also procured, deep packet inspection. There has been no transparency around this. What was the capability? Where's the legal authorization, to even procure this? To what extent is this stifling? And what is the impact that such technologies have on fundamental rights? And I think this is something that within the legal fraternity, within, at the parliamentary committee level or within the judiciary, I don't think that understanding exists in terms of what such technologies, the impact these technologies have on the rights of the privacy rights and the right of expression and the impact they have on citizens' rights. And this is a connection that must be forged. And these are the questions that must be asked. And there has to be transparency. You have to hold the regulator and the executive to account, and you have to find out what has been deployed. We have been discussing this elusive firewall as if there's one firewall that's going to do everything. And in my view, I don't think that's quite it. But what is going to be the impact of the firewall? And most importantly for me, in this surveillance debate, is what is happening with encrypted platforms, because we know, the open lines and the SMS and all of that, everybody operates under the assumption that those are tapped. So everybody uses either WhatsApp as the mode of communication, etc. But again, it's not that easy to breach encrypted protocols, but we know that it has been done now, whether it's at the device level of an individual target, whether through a malware or other things. But we need to know what is happening, to what extent, to what degree, for what purpose. And these answers are just not there. And nobody's really pressing, especially for scrutiny and accountability. Parliamentary committees, and this is a judicial function, and this just has not been done adequately.